So that's
Time to get going.
Change direction, yeah, change careers. So you've been on this, how many years? That's
I think we know that Joe has passed the baton to me to do these further seminars. However, there's a special one which involves Harvey, which we're glad to have. And since Harvey and Joe have known each other since, let's see, the founding fathers were rolling around, I thought I'd ask Joe if you...
Older than that.
So why don't you take
Earlier
it?
lives. Well, it's a privilege and an honor to welcome Harvey Dale here. As I think you know from the information we sent you, Harvey is the director of the National Center on Philanthropy and Law at NYU. That's the only university-based center in the country that focuses on the intersection between philanthropy and law, and philanthropy and nonprofits and law. And in that, he started that center 25 or more years ago. I can't remember exactly when, about 25 years ago. And it has become really the node for research, scholars, and practitioners in the field. It's legal practitioners who specialize in nonprofit and philanthropy law, government officials, people from the Hill, staff members of the various committees, members of the senior officials of the IRS, and a variety of people in the field who work, law professors who teach things dealing with nonprofits and philanthropy, not just domestically, but internationally as well. So and they do a series of seminars and symposia, publish things. They teach a lot of students. It's really a great asset for the field of philanthropy and law. And the reason Harvey, I think, was able to do that is because he has just been fascinated both by the intricacies of law. He is a lawyer's lawyer. He's the sort of guy who used to carry note cards with famous quotations from, sometimes not so famous quotations, but nonetheless quotations from Judge Learned Hand, from a variety of Judge Augustus Hand. You name the major jurist or legal scholar, and he would carry with him. Not only did he carry them with him, but if he would pull them out with the slightest provocation, read it to you, and weep in the process. But the truth, so I'm not exaggerating, but he also, I really am not exaggerating. He now doesn't carry the cards anymore. He has them all on his PDA, along with Shakespeare and God knows what all else, but which he will also read to you with the slightest provocation. We hope he won't do that, but in any event, Harvey has had an enormous amount of experience. A tax lawyer, specializes in international tax. And he has also been the lawyer. He was, from the very beginning, the lawyer for Chuck Feeney, the founder of Duty-Free Shops, co-founder of Duty-Free Shops, and also the person who designed the intricate governance and ownership structure of Atlantic Philanthropies, which, as you know, is not only just a foundation, maybe you don't know it, but it also owns businesses. And how, you might ask, if you know anything about the law, could they do that? The answer is because it's not an American 501c3. It is a charity in Bermuda, the domicile in Bermuda. So it's a very complex structure, and Harvey designed the whole thing. And it continues to operate, and has made a lot of money, and it's given away a lot of money. And I had the privilege of working there for 10 years and learning a great deal from Harvey. And as I said in the book, much of what I know about philanthropy, I learned from him in the process of working with him, and also in the various activities in which he's been engaged. We are also friends that go back to more than 50 years. When he was an undergraduate at Cornell, I was an undergraduate at Chapel Hill. We met at the National Student Congress, which was later revealed to be a CIA front organization. We didn't know that at the time. Have I told enough at this point?
Yeah. I'm getting worried.
Harvey is also a musician. He plays the piano beautifully. He plays the flute beautifully. He also is a raconteur of international repute. And you may get some raconteuring here this afternoon, I'm not sure. But in any event, it is, nobody knows, I can't say nobody, maybe Rich Schmalbeck does. Nobody knows the Internal Revenue Code with respect to maybe with respect to many things, but certainly with respect to its provisions about governing foundations and nonprofits, as Harvey does, because you can, it's one of those, like those jokes, you know, you say 4941, he'll tell you exactly what it is, or you'll say something, you say, oh, that's 4941, 4958, 59, etc. So we'll see how much of that he deals with this afternoon, but in any event, it really is a privilege to welcome a friend of more than 50 years and someone who knows far more than I know and than most people know about the field of philanthropy and law here. And we look forward very much to hearing what you have to say, the wisdom you're going to share with us today.
Harvey, before we go into that, we'll do a run around the table.
I was just going to ask whether we could do
Sure.
Thank you, Joel.
I'm Joel Fleischman.
I'm Rich Schmalbach. I'm a professor in the law school. Lee Berliner, second year MBA at Fuga, intern with Triangle Community Foundation.
I'm Charlie Klopfeld, I'm a public policy professor.
Regine Krushel-Bell, I'm a psychologist and research faculty in the Center for Health Policy.
Barry Varela, I'm the case writer for the Duke Foundation Research Program.
Nancy Bernstein, I'm Director of Foundation Relations for the Medical Center here at Duke.
Joel Huber, I'm a professor in business school.
Andy Karan, I'm also at the business school connected to the Center for Social Entrepreneurship and several other centers there.
I'm David Hannon, I'm the Director of Public Policy for the North Carolina Center for Nonprofits.
I'm Dee Will from the Institute on Care at the End of Life in the Divinity School here at Duke, and I'm the Development Officer here.
I'm Stephanie Wheatley. I'm the Development Officer for the Center for Reconciliation at the Divinity School.
After your introduction, I'm hesitant to say, but my name is Marty Martin. I'm an attorney in private practice representing nonprofit and tax-exempt organizations.
I'm Anthony So. I'm a teacher in public policy and public health issues. I think we met briefly at the law show a few years ago when we worked on.
Hi, I'm Christine Reeves. I'm a second-year master's of public policy student.
I'm Ed Skloot, who also happens to be the brother-in-law of Harvey's college roommate. So, Michael Banner.
Oh,
sure.
I'm Ted Fisk, I'm a journalist, I write about educational things.
John Burris, I'm the new president of the Burris Law.
Congratulations on that, over the international philanthropy. You can disregard a lot of what Joel said, except you can be sure that we've been friends a very long time. So it was a nice opportunity to come down and be sure that I got not only an opportunity to talk with you, but I'm happy to wine with Joel later, because in case you don't know it, he actually knows a few things about wine. We just had about 4 days together in Napa just a few weeks ago, which was a great special plan. What I want to do today is, actually, there's a handout, and I need it too. Are there any extras? I'm going to do a little bit of what at least some law professors do. And then I hope we'll have a more general conversation. But I thought by way of introduction, first I give you just a small dose of statistics. The statistics are dubious, but it'll give you a sense of the scope. And then following that, mention some current developments in the area of interest about international philanthropy. So let me start that way. The statistics, I think, are flawed for a variety of reasons, including the fact that they're very hard to find. But here's what Giving USA has to say. Giving USA is published each year now by the Indiana Center on Philanthropy, and it purports to gather data on giving by individuals, it's U.S. oriented, so it's U.S. individuals, U.S. corporations, foundations, corporations, etc. Giving USA for the year 2008 says, quote, international affairs organizations, unquote, there's the term, received approximately $13.22 billion in 2007, 13.22, which, according to Giving USA, is 4.3% of total giving, and was an increase of almost 13% over the prior year. Their definition of international affairs, I'm now quoting them, is aid, relief, promotion of international understanding, peace and security, and international human rights. And they say that for the period of time from 1991 to 2005, so those are earlier years, giving in this area, international affairs as defined by them, in real terms, grew at 11.5% per year. So this is a significant phenomenon and continuing to grow, and I would bet it will grow faster. Interestingly, using quite different methodologies, there is another publication called the Index of Global Philanthropy. And the Index of Global Philanthropy estimated that in the same years, 33.5 billion was involved in philanthropic transfers from the United States to developing nations. Now, I can't explain the difference between Giving USA's 13.22 and the Index of Global Philanthropy's 33.5. And I haven't tried to probe deeply enough into their definitions or the data. But any way you look at it, the numbers are very large and growing. Second thing I'd say is this is going to receive even more focus as we go forward. One sign of that, which I found very interesting, has to do with the ACT. It's an acronym which doesn't actually work right because it's the Advisory Committee on Government and Tax-Exempt Organizations. The formal advisory committee under the Advisory Committee Act, which is appointed by the Internal Revenue Service to advise their function on, among other things, tax-exempt organizations. And each year, the folks who are appointed to it, it's a very distinguished cast of characters, pick as a topic something on which they will brief the IRS function, the exempt organization function, and their choice this year is international philanthropy. And the report will be written by the person who this year is chairing the ACT, whose name is Fred Goldberg, and Fred is one of the only two people in the history of the world who has been Chief Counsel of the Internal Revenue Service, Commissioner of Internal Revenue, and the Assistant Secretary of the Treasury for Tax Policy. So he knows something about taxation. It's interesting that that is so. What I want to do en route to talk more generally, and I think in an audience which has only a limited number of lawyers, I'm going to start talking primarily to law students, but then I want to move on. And so I thought, just as a way of organizing it, I'd start talking about international philanthropy by talking about U.S. individual giving and U.S. for-profit corporate giving international. Start there. And then talk a little bit about U.S. private foundation giving to foreign charities, and then about U.S. public charity giving to foreign charities. And then talk a little bit, if there's time, about U.S. charities which invest both within and outside the United States and just give locally invested and as it hits charities. One of the important rules about law school is that we still tend to operate on the Socratic method, which means there's usually dialogue between professor and student. In fact, one of my favorite definitions of the alternative method lecture is that a lecture is a technique of getting the professor's notes to become the student's notes without passing through the mind of either. And I would like to avoid that. So I hope what we'll have is interruption and dialogue as we go along. So we're not going to wait for a Q&A period. I hope the whole thing will be open. In my regular class, I get names, so I can call on people and they resort to that. What I'd like to do to start, though, this will only zero in on being relevant after about 3 steps. But let's start with what a law school class might look at, dealing with charitable giving in the Internal Revenue Code. I've printed out for you 2 pieces of the relevant provisions. My longtime friend and colleague, Rich Smallback, was kind enough to bring the Internal Revenue Code because I don't feel good about talking about taxation.
I thought you brought it.
Just to be clear, was that your request?
Yeah,
that's a bad traffic revenue.
Yeah. But this, folks, really is, I mean, this is the tax law, not the regulations, not the cases. This is just the statute. This is the Internal Revenue Code. And it contains only provisions of law adopted by Congress, signed by the President, that have become law. If you add in the regulations, which are another 7 or 8 volumes, and then cases, you'd have mind-boggling complexity, which is why this is a field in which it is not at all unusual for the best and the brightest to decide they want to run down that strange path to go on and get a degree after a law school degree and get a master's degree in taxation, which takes another year, and then it probably takes 3, 4, 5 years of practice after that before you really kind of get the hang of the thing. It's very complex. So we're going to start with a little piece. And I printed out for you, and I hope you'll have them side by side, because we can have just a little bit of fun with this. I say that we get relevant after about 3 steps. The provisions of section 170C2 and the text of code section 501C3. Let me explain what the difference is. The first, 170C of the code, is the provision that gives an income tax deduction under appropriate circumstances for people, corporations or individuals, who give money to charity. So 170C deals with the income tax deduction for charitable giving, the treatment of donors. The second provision, code section 501C3, deals with the definition of a charity, and code section 501 and the sections following it deal with the tax treatment of the entity. So the first deals with the donor, and the second deals with the donee, charity. They have very similar language, and what I want to start with is the language. Take a look at section 170, 170C2 in particular, and 501C3. We're just going to deal with an analysis of the words of the statute. And what would the maxim with which we're dealing is a maxim of statutory interpretation. How do you make sense of the words of the statute? And in particular, how do you make sense of the words of the statute when 2 very closely similar provisions have slightly different wording? One possibility is that the differences don't mean anything, and you should read the 2 together to make them understood the same. Another way is just the opposite. The words mean a lot, and if you find a listing in one and it doesn't contain something that's in another, that's intentional and makes a difference. That second line of reasoning is sometimes called reasoning by negative implication, or in Latin, and law students get talked to in Latin from time to time, inclusio unius est exclusio alterius. Include one, you exclude the other. Let's take a look at the flush language, the top language in 170C2A. I'm sorry, 170C2. This is describing now the types of entities to which you can make a tax-deductible gift. So if you make the gift, you're going to get a tax deduction. And it says that includes, and a lot of words following it, but that includes a corporation, trust, community chest, fund, or foundation, meeting certain requirements. Now take a look at the provisions that describe what kind of organizations can be charities and therefore themselves treated as tax exempt. It's corporations, any community chest, fund, or foundation with following language. What's the difference?
No trust.
No trust. So it would follow, if this was intentional, that charitable trusts couldn't be 501c3 organizations, right? You could get a tax deduction for giving to them, but they wouldn't be 501c3s, right? That's what the word says. Of course, that's not the answer. But it's important to see that it could be the answer. The regulations, Treasury regulation, the regulations under the Internal Revenue Code that state how it is to be interpreted and have a very high level of authority. The statute sits at the top of the heap, but just underneath that are regulations adopted by the Treasury. The long-standing regulations adopted by the Treasury say the following. Remember, they're interpreting corporations. They say articles of incorporation, that's the way you form a corporation, with a certificate of incorporation or articles of incorporation. They say, quote, articles of organization include, quote, the trust instrument, unquote. Cute, right? Cute. Preposterous. But it was intended to say, hey, this difference is not going to matter for this purpose. And the law is very clear that despite the fact that trusts are mentioned in 170C and not mentioned in 501c3, charitable trusts are and can be 501c3 organizations routinely are if they meet the other requirements. The maxim, inclusio unius est exclusio alterius, does not apply. Let's go back to 501c3. Compare the substantive things that the organizations can do if they're going to be tax exempt with the things the organizations can do under 170C2B. What kind of purposes can they have? You'll notice that in 501c3, they can be operated for religious, charitable, scientific, testing for public safety, literary, or educational purposes, goes on. Look at the listing in 170C2B. These are organizations operated for religious, charitable, scientific, literary, or educational purposes, etc. What's the difference in the listing? Yeah, testing for public
No
safety.
public safety.
Testing for public safety. So an organization testing for public safety certainly can be charitable. Can you get a tax deduction for giving to it? It's not listed in 170C2. In one of the leading cases in the field, Bob Jones University, desperately important case on the definition of charity, Justice Powell, concurrent, wrote as follows. Federal taxes are not imposed on organizations operated exclusively for religious, charitable, scientific, testing for public safety, literary, or educational purposes, unquote. He's just quoting 501c3. He goes on to say, this is his quote, the code also permits a tax deduction for contributions made to these organizations, unquote. Does that mean you get a tax deduction? I mean, he said you did.
Yeah.
Just wrong. Wrong. There's a perfectly square revenue ruling that says you don't. Revenue ruling 65-61 squarely holds that you cannot get a deduction for a gift to an organization that tests for public safety, even though it's listed in 501c3. And there's a lot of other authority that confirms that. The maximum does apply, but you can't tell by looking, right? It also proves to you, authority tells you the answer, that the general statement that Powell made, which is made by a lot of people, is wrong. You don't get a deduction for any gift to a 501c3 organization. You only get a deduction to a 501c3 organization which happens to be described in 170C2. And that's a smaller subset. Let's go back once again. Look at the flush language at the end of 170C2. This deals only with contributions by corporations. So this flush language doesn't deal with the deductibility of gifts by individuals, but only gifts by for-profit corporations. It says a gift or contribution or gift by a corporation to a trust, chest, fund, or foundation shall be deductible only if it's going to be used within the United States. You see, here's where we're going to get a linkage back to the topic. What isn't listed there? Trust, chest, fund, or foundation. What's missing? Corporation. Okay, does that matter or not? If a U.S. corporation gives money to a U.S. corporate charity, a charity that happens to be corporate in form, and that U.S. corporate charity uses the money outside of the United States, does the donor get a deduction or not? To put it another way, does the maximum apply? If the maximum applies, then the answer is yes. The word difference is going to be significant as a matter of law. If it doesn't, it won't. Once again, you need to get authority. The answer, and the authorities are very clear, is yes, you do. If you're a U.S. corporation and you want to make a gift to a U.S. charity, and the U.S. charity is going to use those funds abroad, you better make it to a U.S. charity which is corporate in form. Corporate in form. Now that's kind of interesting to me. These aren't very complicated and long provisions. But we have at least one case where the doctrine inclusio unius et exclusio alterius applies, and there's square precedent for it. We have two others where they don't, and there's square precedent for that. That's very strange to me. It's hard for students to come to a body of statutes and not know how to interpret them. And the answer is the Internal Revenue Code always means what it means, and the way you find out about that is you look for square precedent. You can't always do it on the face of the statute. It's too hard. And the doctrines and canons of construction aren't reliable enough. Anyway, sorry.
What would be a case of a non-corporate structure, just a collaboration of individuals,
Well,
let's say getting out of Darfur?
Well, the listing, that would probably be in the form of a partnership, and then you'd have to penetrate through that for other reasons. The kind of example you face here is if you had a U.S. corporation which was interested in helping in Darfur and wanted to make its contribution in the United States, and you'll see that there were very good reasons for the corporation wanting to do that. If it wants to do that, it behooves it, if it wants a deduction to make sure that the U.S. charitable donee is corporate in form, not a trust.
Trust.
Not a trust. And the typical, the most common, they're not the only forms, but the most common by far forms for a U.S. charity is a corporation and a trust, nonprofit corporation or a charitable trust. And there are others too, but those are by far the most common. Okay, having come this far, that's enough, I think, of statutory interpretation. But it does get us, I think, to noticing already just this is a relatively small issue, not a big problem. But if you're a U.S. corporation, you want to engage in international grant making, and you want to be doing your gifts in the United States and getting an income tax deduction, a corporate income tax deduction, then if those funds are not going to be used within the country, you better be sure that the donee is corporate in form. Yes, a charity, but a corporate charity as opposed to a trust. Why? There is absolutely no reason for that. There is nothing in the legislative history that explains it. There is no public policy of which I'm aware that makes that of any importance, but it is the law and there's authority for it. So we now see already that there are restrictions on international grant making that wouldn't apply to domestic grant making.
Is there a conspiracy solution to this? I mean, was somebody behind these omissions, or would you say it was purely just random ineptitude on the writer's part?
This is the most complicated statute in the world. And it's impossible to have the words become coherent. There actually have been several important people in history, known to almost nobody, although I could give you their names, who labored for decades, doing nothing but trying to make the words in different places in the code coherent. But it's inexhaustibly complex, and it never works completely well. So you're left with possible inconsistencies, and then the question is, do they matter or don't they? And a lawyer has to go out and find precedent, failing which you're kind of worried.
So you don't know what happened in 1986 when they wrote this?
They didn't write this in 1986. They wrote this in 1935. The Internal Revenue Code of 1986 just picked up the Internal Revenue Code of 1954, which picked up the Internal Revenue Code of 1937, which picked up prior statutes. So some of these words, 501c3 has been with us since 1913.
So when they amended it, they could have fixed this.
I mean,
they could have fixed this when they amended it.
They could. But in fact, another thing that happens is no one's going to amend 501c3 to add the word trusts, because 501c3 has been around literally since 1909 in one form or another, and it gets to become hallowed ground. And there's enough precedent by now that a lawyer can find a way through.
The contribution deduction, I think, came out a few years later, so they weren't written at exactly the same time and possibly not by the same people, although you would like to think that the second person had the first text in front of him when he was working. But
that's right. I think the first deduction provision was 1917.
Yes.
But the Internal Revenue Code was first passed, the first taxing statute that was constitutional, that had an income tax, was 1913. But the 1913 provision had an exemption for the entities, equivalent 501c3, and it had been borrowed from an earlier act that was an excise tax, not an income tax, 1909. So these words have been around a very long time. They just get picked up and carried forward. Sometimes they have meaning, and sometimes they don't. One of the things I always tell my students is that the Internal Revenue Code is not written in English, and you should not expect the words to be understood as English words. Let's take a look again at section 170C, and notice particularly 170C2. C2A says that no income tax deduction will be allowed unless the donee institution is created or organized in the United States. That's perfectly clear, and there's not much argument about what it means. But when it was passed, which is I think in the early 30s, the legislative history said two things, one of which was wrong and one of which was right. The thing it said that was wrong was that the income tax deduction is given in recognition of the policy that we need help in charitable activities within the United States. There's need here. It said approximately that. That's not a quote, but close. That's clearly wrong. That's not how come the deduction was there, and it wasn't so written until 35, and we've had it since 1917. And most countries in the world that recognize a charitable deduction, and it's pretty widespread in some form or other, permit the deduction even though the proceeds can be used outside of the country. So it was not good history, it isn't good logic, but it did say that. Wrong. Here's the other thing the legislative history said, which was right and continues to be the law, that if you make a gift to a proper U.S. organized charity, and that charity decides to use the money outside the United States, that's fine. That's fine. So the use of the funds can be wherever it may be, even though the legal skin of the entity must be created within the United States. Now, the moment you see that, you realize we're already dealing with a matter of some kind of formal triviality, right? But you also realize, at least if you've been trained at the NYU Law School or under Rich, that opens an interesting possibility. Because if I now want to give a gift to a foreign charity, I know how to do it, right? I give a gift to a U.S. organization, and the U.S. organization gives the money to the foreign charity. Will that work? Can I do it in that triangle? Sometimes, but not always. Because the code is full of rules that sometimes apply and sometimes don't. They're usually grouped together in a notion that, as a general matter, substance prevails over form. And as I said, I've taught now for 35 years at the NYU Law School, and a lot of that time I taught tax. And my students came from great law schools where they got their JD degrees, and they only had a limited number of tax courses. Sometimes one, sometimes two, some of the real maidens had 3. And very commonly, they were told that substance prevails over form, and that's a basic doctrine in the tax law. And I always say 2 things to that. One is, if that's true, why are you paying tuition to come here? Everything's going to come out the same no matter what you do. The end result is always the same. Why would you waste all of your opportunity course trying to learn how to be a tax lawyer? That's only a little bit lived. But the second is the true rule. And the true rule is that substance prevails over form, except when form prevails over substance. And that's the true rule. And the hard thing is trying to figure out when, and that requires precedent. But I could give you, I won't, dozens and dozens of examples where nothing is at stake but form, and the outcome depends on the form, and the taxpayer is free to choose the form, and that tells the students also why they should pay tuition to come to law school and learn more about tax, because you can make a difference for your clients. And I've done that for a long time, I hope, over my career. What do you do about this? Does form prevail over substance, or does substance prevail over form? If form prevails over substance, my triangle does it, and I can eviscerate the statute. All I need to do is create one U.S. charity, and I really want to support, who knows, the Sorbonne. And I give it to the U.S. charity, and I say this is for the Sorbonne. I get my deduction because that's formed within the United States. I'm not constrained by 170C2A. And the Sorbonne gets the money. Is that okay? Well, the service was troubled about that for a long time, because the service knows, too, that at least sometimes substance prevails over form, but maybe not always.
Your act of giving to the U.S.-based charity is tax deductible.
I'm sorry, I can't hear you.
Your act of giving to the U.S.-based charity is tax deductible. But the U.S.-based charity's act, subsequent act of giving to the entity abroad, is that tax deductible too?
U.S. charity doesn't pay tax, so it doesn't need the deduction.
Oh, so there's a third piece of law which says U.S. charity can spend on anything it wants under the sun with no taxation.
It doesn't have to spend on anything, just take the money and keep it. You can invest it. That's what 501c is about. 501 says, remember, we have separate treatment for the donors, individuals and corporations and other tax-paying entities, and the donees, the charities that receive it. And in general, subject to some exceptions, but in general, charities are exempt from taxation. In fact, 501c of the code, 501c3, that paragraph, deals with charities. 501c, that subsection, lists all of the organizations that are tax exempt. It has 25 or 26 subdivisions. 26. And there are several other places in the code. There are a lot of things that are tax exempt. Cemetery organizations, veterans organizations, labor unions, social clubs, voluntary employment benefit associations, and on. Charities are in C, paragraph 3, 501c3, and they are the most exempt from tax of all of the entities in 501c. So they don't need a deduction. If I do this right, therefore, the deduction comes here, and it doesn't matter any
But there are several things that it specifically says they can't spend the money on in 501c3, including lobbying and distribution to shareholders and things like that. So,
But if you put your money into the charitable organization, you don't have the right to tell them how to spend it, do you?
Well, it depends on what you do. There is this thing called donor intent, and I could certainly give money to United Way and earmark it. They permit that, of course. So if I want to give money to United Way of America and say, here's my gift to you, United Way, and I want this to be spent on the YMCA in my local community, they'll take the money and spend it that way. So you can, yes, earmark it. And if I want to give money to Duke University and say, this is for scholarships, not for faculty salaries, I may be making a big mistake, but I can do it. So there are levels within which you can earmark, but that's part of the question. To what extent can the donor control where that money is going to go?
That's my question.
And still get a, in other words, where is the line here between substance and form? And the service answered that question somewhat in 1963 in a revenue ruling called Revenue Ruling 63-252, 63-252. And it contained 5 situations. So it said on these facts you can get a deduction, on these facts you can't get a deduction, and so it drew the line down the middle. And one of the things it said was, if there is too much donor control, designation, complete control over where the money's going to go, then, I guess they would have said, substance controls over form, and 170C2A denies the deduction because the entity in the middle doesn't have discretion and control. It's merely an agent, and the real transaction is you're giving directly to the foreign charity, and you don't get the deduction. On the other hand, if you don't have complete earmarking, and you permit the intermediate institution, the U.S. charity, to have some discretion, then you can get the deduction. And the question is, how does one draw the line? Today, in the United States, you can step back. The Internal Revenue Service maintains a list, which it calls the master file, of all charitable organizations in the United States. For a lot of reasons, that master file is not accurate. Some organizations don't file even though they should. Some organizations stop filing after a while. Some organizations never have to file. For example, religious organizations and churches never have to file. Some organizations can file a group return without listing all the members of the group under certain circumstances. So there are a variety of reasons why that master file is less than perfect. And that's somewhat of an understatement. The master file, however, contains over 800,000 charities, 501c3s alone. And if you do nothing but search the names of the master file, over 800,000 entities, for the words friends of, you come up with just under 1,000. Let me give you an example of an organization that's a Friends of. There are many like this. There's an organization called the Friends of the Sorbonne. It's a U.S. charity. If you gave money to the Friends of the Sorbonne, would you expect them to give it to Harvard? Would you expect them to give it to Cambridge in the UK? All of that money is going to go to the Sorbonne. The service routinely rules that that's fine, that the deduction is permissible for the gift to the organization, Friends of the Sorbonne. Now that's the 2-step, right? And there's no problem. Nobody thinks that money could possibly go anywhere else. But the system is structured so that the donor doesn't put the restriction on it. The donor institution has said what it's interested in doing, the U.S. charity. As I said, there are about 800 or so organizations on the master file listed as Friends of organization, and that's a severe undercounting, because there are many, many other organizations that do the same thing without having Friends of in their name. I happen, for example, to be the president of the U.S. charity, which is called Southern African Legal Services Foundation. It's really a Friends of organization for a human rights organization in South Africa. And 100% of the money that goes to that organization, Southern African Legal Services Foundation, is going to go to the Legal Resources Center in South Africa, no matter what. And the service knows it, and the donors know it, because otherwise they wouldn't give money to it. And that's perfectly fine under this revenue ruling. So the answer here is substance controls a little bit, form controls a lot more. But still, you've got to be careful to dance the dance the right way, to do the minuet the right way. If you're a U.S. individual and you want the tax deduction, this restriction, the 170C2A restriction on the place of organization, also applies to U.S. corporations. And as I've shown you before, U.S. corporations have that additional strange requirement requirement that if the funds are going to be used out of the United States, the donee also has to be a charity which is corporate in form. All of this, not in my view, rational, but there. The legislative history of most of this stuff is also less than satisfactory. And in an article I wrote 15 years ago, something like that, on foreign charities, I suggested that a very simple solution would be the repeal of Section 170C2A, the place of formation rule, which would take a lot of this away, and also the repeal of, or the addition in the flush language, or the repeal of it would do just as well. It would put in trusts into the flush language and get rid of that restriction. That's not going to happen very soon. It's hard to amend these provisions. But what has happened, I'm happy to report, is that the Internal Revenue Service, I believe quite prudently, has not in the last 15 years raised this question once, so far as I know. And that's appropriate too. At some juncture, when you have limited resources, it isn't worthwhile fussing around with these formal issues, particularly when there's such a simple way of bypassing them. Because if you do start enforcing it, what you usually get is very little revenue and a punishment to the uninformed who have made a footfall, which is not necessarily sound public policy. Let me stop on this before we go on to some other aspects of international giving, just see if anybody has questions or thoughts about the desirability of promoting or restricting U.S. individual or U.S. corporate giving to international causes.
See if this question is right. Take a moment and talk about the recent troubles of foundations giving money to groups overseas which liberally interpret their peacemaking, international cooperation, similar purposes, and Ford Foundation winds up giving to groups that purportedly are in fact terrorist organizations. We've had in the last couple of years, as you well know, a lot of conversation and some move to legislation, regulation about this subject. Where are we?
I think we're in a complicated place, and in order to get at this, I was going to do this in just a minute because it's a little bit easier after we talk about some of the private foundation rules that affect private foundation. Let me do that, Ed, because I think it'll be a little more coherent. We need to talk about the so-called voluntary guidelines, and we need to talk about foreign equivalency determinations too. It'll make more sense if I can explain what that structure is. It'll be just a minute.
Tell me if this is off your topic, but there's a lot of interest at this point in the restrictions on churches and other religious groups getting involved in political activity with some strange lines. A few months ago, the administration went after some churches. I understand. I haven't heard anything about it recently, but any thoughts on?
Well, let me clarify that. That doesn't have to do with international grantmaking, but maybe I can clarify two things about that. The administration didn't go against churches. It was the Senate Finance Committee, Senator Grassley. Senator Grassley asked 6 televangelist organizations to provide information to the Finance Committee. One of them did. 5 of them said we won't, and you don't have a right to ask us. As of July or so, that was the place of stalemate, and there was not much progress being made. I think Senator Grassley, at least at that point in time, decided that there was too much risk in trying to address them. They were represented by 2 large law firms in Washington, and one of the lawyers had been the head of the exempt organization branch in the service for 30 years, 20 years. So they're very well represented, and I think that is at the moment in stasis. Who knows what happens after January, but between now and then I think that will be in stasis. The question about ministers preaching political campaign from the pulpit is a question that has to do with a doctrine called unconstitutional conditions. And to understand that, let me start with a simple way. Unconstitutional conditions. If Congress, remember these laws are congressional, it's not the Internal Revenue Service, these are written in the statute. If Congress decided to say that under no circumstances could a minister talk about political campaign activity, that would be flat out unconstitutional. It would take no time to determine that, just a laydown. Suppose, however, that the United States says, I'll give you an example. Suppose the United States says, we want to pay for a program to provide postnatal counseling to pregnant women. But we want to pay for that, and we don't want to pay for abortion advice. So we're going to ask any organization that wants the money, if you want the money, that you have to agree this is for what we're paying you for, prenatal and postnatal counseling on health of children. And you have to agree you're not going to use it to provide abortion advice. Now suppose you were Planned Parenthood. Could you challenge that? Could you say, listen, I want the money, but I still want to give advice on abortions? Well, they did. That case is Rusty Sullivan, and went to the Supreme Court about 8 years ago, 9 years ago, not right? And the Supreme Court said, no, that's okay. If Planned Parenthood wants to talk about abortions, it can do it in another physical space, or it can decide not to take the money. But if it takes the money, it has to take the money for the purposes for which the United States wants it to use the money. Let me give you another example. Suppose the United States says to you, we'll give you a benefit, you don't have to take the benefit. We'll give you a subsidy. But if you want the subsidy, and you choose it, you don't have to take it. Then you can't lobby too much. Lobby a little bit, but not too much. Is that okay? That's been in the law since the 30s. Charities, as defined in 501c, can't lobby too much. You have the statute in front of you. It says, 501c3. No substantial part of the activities of which is carrying on propaganda or otherwise attempting to influence legislation. That's lobbying. So if you want to be a 501c3 organization, you can't do too much lobbying. Now lobbying is pretty core speech. That's First Amendment stuff right down the middle of the fairway. So an organization called Taxation with Representation took that to court and said that's an unconstitutional condition. You can't condition tax exemption on me giving up my right as an organization to speak on legislation. That's First Amendment speech. Supreme Court of the United States, in the case Taxation with Representation against Reagan, said no, you can't. It's okay for the government to do that. If you want to be tax exempt, then you can't engage in lobbying. You can, of course, said the court, set up a separate organization, not a 501c3, but a 501c4 organization, the next paragraph in the code. And that can do as much lobbying as it wants to, but it can't receive tax-deductible gifts. Now, it's still tax exempt, but the difference between the two is that the donor is not getting a deduction for supporting the lobbying. And the Supreme Court said as long as that can be done, you can have a C4, the speech can go on, and the burden is not too great, so that's okay. If you look at 501c3, right after the lobbying restriction, it says the organization does not participate in or intervene in any political campaign on behalf of or in opposition to any candidate for public office. That was put in by Lyndon Johnson in 1954. He didn't like the fact that one of the nonprofit groups was opposing his reelection. And the public policy behind this is Lyndon Johnson. That's what that is. Now maybe it's good, maybe it's bad, but that's where it came from. Is that okay? Well, that's been litigated several times. And the answer is sure that's okay. It's been upheld by the DC Circuit, right? In Ranch Ministries. That's the case, right? The Church of Pierce Creek. And they said, fine, if you want to do this, here are the ways you can do it. You want to do this, you can set up a 527 organization, a political organization, and then you can talk. But you can't decide you want the subsidy of tax exemption and take it on your terms, not the terms on which Congress is prepared to give it to you. That's what's involved in this. There's no question that if any of those ministers wants to engage in free speech, the minister can get up, walk out of the church, take off his or her robes, and say whatever he or she wants about a political candidate. But you can't use the tax-deductible contributions coming into the church and therefore the church property in political campaigns if you want to remain tax exempt. You can give it up if you want to, choice. So the difference here is between what you can do mandatorily, could not prevent anybody from speaking about a political campaign candidate, First Amendment, and what you can do is a condition on a privilege. And sometimes you can condition privileges, and sometimes not. And the law surrounding the interpretation of unconstitutional conditions is very complicated, very ill-formed, and can only be resolved by further litigation. So we'll get there. That's a long answer. It doesn't have too much to do with international affairs.
Can you describe how lobbying is defined in the domestic and the international context in other settings? So lobbying, assuming the United States, is much more related to legislative and not executive branch stuff you can do after, right? But,
Well, there are.
But in developing countries where back the parliamentary system,
4 or 5 different definitions of lobbying for various purposes, because different types of organizations are subject to different types of restrictions. So there is no single definition. And there are different rules that apply for purposes of certain kinds of lobbying, like grassroots lobbying, than for direct lobbying. And lobbying can involve dealing with the legislators or dealing with their staff, and there are exceptions also for self-protection lobbying. So if somebody's trying to pass a law that directly affects your organization, you can speak in that. Those rules are enforced in 2 ways. 3 ways. One, by the denial of certain deductions if there's earmarking or spending for lobbying purposes within the special definitions. By termination of tax-exempt status if there's too much lobbying under 501c3, with an election that now can be made to protect against that. I'll come back to the election in 3 minutes. And in the case of private foundations, by an excise tax on lobbying expenditures, so that if you're a private foundation and you do this, you pay a penalty tax based on the amount you spent on improperly on the lobbying. So the rules are complicated. The only reason they would arise in the case of lobbying by a foreign organization, which in general would not be subject to any of these rules because it is, after all, foreign, is if that interfered with the foreign organization being treated as a charity for purposes of a gift by a U.S. organization. And we haven't quite gotten there yet. That's where Ed Stewart wanted us to go to, and I'll get there in a minute about how U.S. charities, private foundations, and public charities can make gifts to foreign organizations. What do they have to do to determine that the foreign entity is kind of like a U.S. charity? I should come back to that election just a little bit. In 1976, remember these lobbying restrictions have been in the code since the 30s, 35, the 30s. In 1976, because there was confusion about what substantial meant. If you look at 501c3 again, you see it says no substantial part of the activities of which carry are in lobbying. What substantial? Is it 51%? Is it 76%? Is it 43%? What do you do? There was confusion, and there was a belief maybe that the confusion wasn't helpful either to the service or to the charities. So Congress passed a provision to the code, section 501H, that allows charities to make an election if they want to, except churches, which didn't want to be in this because they wanted to claim they could do it anyway. But charities, except churches, can make an election under which their compliance with the lobbying rules is measured mechanically. And if they make the election, then they just put in numbers into a tax return, and the numbers are less than $1 million and less than a certain percentage. It's a home run. And most well-advised charities should do that. And there's been a campaign since the regulations were made final in 1986 to get most charities to think about making a 501H election, because it's almost always positive and there was no negative to it. And that's been pushed very hard by some of the leading organizations in the field. And as of today, great success. I think just over 1% of relevant charities have made the election. Should we go on to the private foundation? What we finished with so far, nice conversations, I'm ready for the questions. What we finished is now that there was a discussion now of the tax treatment of donors, tax deductions. I'm skipping over some other important, interesting provisions. Maybe I should mention them just quickly. It matters a lot to donors, not only whether they get the income tax deduction, but whether they get a deduction for gift or estate tax. So if I'm a living donor and I want to make a gift to a charity, if I don't get a gift tax deduction, I can be subject to a tax which is actually in numbers much higher than the rates that apply on the income tax side. Same thing if I leave property in my will, can I get a deduction for estate tax purposes? Unlike the provision for the income tax, the charitable deduction for gift tax purposes and estate tax purposes, the transfer taxes, do not have a place of organization restriction. So on face, that looks very good for international charity. The problem is, and this is somewhat opaque, is that there's another provision in the code, there's a lot of stuff, that says that if a charity fails to come to the Internal Revenue Service and say, hey, I'm a charity, turns out the period of time within which you can do that is 27 months after you first started activities. If you don't come to the Internal Revenue Service and say, please confirm to me that I'm a charity, give me a determination letter. If you don't do that within 27 months, then you're no longer treated as a charity, whether or not you're actually a charity. You're not treated as a charity for the income tax provisions or the transfer tax provisions, And that is a bizarre result, because that means that although on the face of the statute, there's no place of formation restriction, for almost all charities in the world, de facto, they don't qualify, because they're probably, nobody knows for sure, best guesses are at least 50 million charities outside the United States, at least, nobody knows for sure. At last count, there were, I think I'm right, less than 1,000 foreign charities that had ever come into the United States to ask for determination letter, less than 1,000, and fewer than 600 that had their filings up to date. So that meant that of all of these, say 50 million, the ones that actually work for charitable deductions for gift or estate tax purposes is a tiny subset. That's the way the statute works. The Internal Revenue Service almost always disregards that. That's very strange. So the law here is just confused. That provision should, in theory, cut off the deduction for gift and estate taxes, but most of the time the deduction is permitted. That's probably wrongly, but it's permitted because it isn't challenged. Okay, now we're finished really with the treatment of the deductions to the, let me say one more thing about deductions. Those gift and estate tax provisions are very important. For example, does Bill Gates care, or does Warren Buffett care about the income tax deduction for their gifts to the Gates Foundation? I don't think so. The deductibility, as you probably know, is limited in the case of gifts from private foundations to 30% of an individual's income. Do you think Bill Gates' income, in order therefore to get the deduction, you'd have to have, if you gave 30 cents, you'd have to have $1 of income, or at least 3 times as much. You think Bill Gates' annual income is 3 times $30 billion, which is what he's given so far? Or Warren Buffett's, who's promised to give 45 or 50 billion, depending on the price from time to time. Berkshire Hathaway, which I would bet is down a little bit today, maybe up tomorrow. Market was off 570 as it came in. They don't care very much about the income tax deduction because they don't have enough income. They care an awful lot about the gift tax deductions. If they did not get gift tax deduction, those gifts of 30 billion or 40 billion or 50 billion could be subject to taxes as high as 55%. So the transfer tax deductions really matter. The income tax deductions only matter in the hands of little people who make a couple of $1 million. Big people who give away that kind of money. Now I'm really finished with the going. Let's talk about private foundations, because I think it's a good way in Ed's question. We have time to talk about public charities. Private foundations have been subject to a much more complex set of rules, much more rigorously applied than the rules that apply to so-called public charities, and that's been true since 1969. There is a trick, of course, and that is knowing what is a private foundation as opposed to a public charity. That's the subject of 5 two-hour sessions in a course I teach on this, which is extremely complex. So I don't propose to replicate that here. But you can think about it as involving 2 different types of exception, because it works by exception. The way the definition was written into the code and remains in the code today is by subtraction. The code says absolutely explicitly that every 501c3 charity, every 501c3 charity is a private foundation, unless, and then there's a code. You got to get out of it. So simply by being a charity, you're presumed to be a private foundation for purposes of these very tight rules. You can get out. One way to do it is there are 9 ways out. Another way to do it is there are 4 ways out. I think of it probably better understood as 2, but I'm only grouping the same exceptions. One kind of exception is the entity is publicly supported. So that unlike, what's a good example, the Ford Foundation, which got most of its money from one member of the Ford family, you could have United Way of America. United Way of America gets money from lots and lots and lots and lots of people. And so it's publicly supported. And if you can draw the line, and there are 2 different tests for it, 2 different provisions of the code, if you can draw the line and show that you're publicly supported, you can avoid being a private foundation and become a public charity. The second way out is by carrying on certain kinds of activities. And those activities include being an educational institution, being a hospital, being a church, what am I missing? Being a supporting organization for a public university, Missing anything else?
Scientific,
Yes, scientific.
blah, blah, blah.
So there are a few that if you can prove that that's what you do, you're okay. This is a kind of a strange configuration, right? And it came from the fact that for more than a decade, Wright Patton had conducted a series of hearings because he was certain that there were massive abuses going on inside private foundations in the United States. And those hearings are lengthy. And for sure, there were abuses. And for sure, he found them. And in response, he wanted to set tighter rules for the future, primarily to punish the people who had been bad in the past. And drawing the line was complex. The policy theory, if there was one, was that publicly supported or good activities. If you're publicly supported, went the argument, then there are a lot of people overseeing what you're doing. And because each of those donors has some stake in the organization. And therefore the likelihood of abuse is smaller. That's syllogism number one. Syllogism number two, or policy number two, is if you're doing these wonderful things, the religious organization, that even had a First Amendment freedom of religion piece in it, or you're an educational institution with a regular faculty and a venue where you can teach, or you're a hospital, then there are enough other people who are paying attention to what you're doing, so the likelihood of profound abuse is smaller. For myself, I'm not unduly persuaded by either line of reasoning. I would guess, in fact, that the likelihood of abuse in the United Way of America, remember the head of it went to jail eventually, is less likely to be picked up by a regular donor to United Way than some possibility of abuse in the Gates Foundation, because Warren, Melissa, or Bill are more likely to see it and they'll do something about it. So it doesn't persuade me that publicly supported is somehow more accountable than closely supported. It just doesn't ring true to me, but that's Congress thought so, and so they wrote those rules. And because they wrote those rules with those two theories, the exceptions matter. Publicly supported, with a lot of the regulations go on for, I think I'm right, 26 pages on how to apply those tests, the two different tests. Or one of these special exceptions. We're going to deal now with the private foundation rules. And because private foundation, let's suppose you have failed the exceptions, and so you are a private foundation, or a charity, and therefore by default a private foundation, and you haven't managed to get out through any of the exceptions. You're subject to a series of rules. And among those rules, Joel actually mentioned 4941, are some rules on self-dealing, which is in 4941, but there are some other rules that are pretty important, like not making investments that jeopardize the purposes of the organization, and not...
Yes. She said it's hard these days.
Yeah. That's right. And not making certain kinds of expenditures, paying money out in certain ways that the Congress decided was bad. Private foundations are not, in general, and the most important rule here, because the real pressure comes from this rule, is that private foundations must spend approximately 5% of their net worth each year. It's not measured by income, although it's called a minimum distribution test. It's measured by the size of the assets of the entity. That was not always the case, but it used to happen. And they have to spend that every year, and the question is what counts as a good distribution, a so-called qualifying distribution? Because if the private foundation doesn't meet that spend rate, roughly 5%, it's subject to pretty severe taxes. The taxes in all of the provisions dealing with private foundations are excise taxes, and they all come in two tiers, spelled T-I-E-R-S, but could be spelled the other way too. The first imposes a tax on the entity, and usually at a slightly lower rate on the managers, the foundation managers, who would be the board of directors or the senior staff. And then the second tax applies if the problem hasn't been corrected. And there's usually a period of time within which the infraction can be corrected, and correction normally means undoing it completely. And unless it's undone completely, the second tax applies. And the second tax, I think, in every case is at least 100%, and in some cases is 200%. Am I right about that? Yeah. 200% is a pretty high tax rate. So you want to make sure you don't do this. So What counts then as a good distribution? You want to make sure it's good. Well, here's a great idea. Suppose that I'm the Ford Foundation, and I want to get together with the Mellon Foundation, and I don't like what Wright Patton did to me. So I say, I'll tell you what I do. I'm the Ford Foundation. I'm going to pay 5% of my income to you, my assets to you every year, and you do the same to me. Yes, that's good. Can we do that? Wouldn't that be terrific? The 5% spending would have been nothing, but Patton was trying to do what the Congress was trying to do, is to get that money out of the private foundations and into other charitable institutions. That was the goal of the minimum distribution rule. So, a minimum distribution does not include a payment to a private foundation in order to prevent this recycling activity. So it's explicit. There are a lot of other rules. Take just that one rule. Now suppose you're a U.S. private foundation. I just start with the one rule that a gift from a private foundation to another private foundation doesn't qualify for the 5% distribution. And sure, so otherwise there'd be nothing left. I'm now a U.S. private foundation, and I want to make a gift to the Red Cross. How do I know it's not a private foundation? It's not U.S. The 501c3 doesn't have any place of organization in it. How do I decide whether it meets the public support test? How do I decide whether it's one of the types of organizations that's, like a hospital or an education institution? What do I do to make those determinations? These tests are actually quite complex, so it isn't enough to look at the Red Cross in Switzerland and say, gee, it looks like it's publicly supported. You have to create ratios. There are numbers that go down one column and numbers that go down another. You've got to add them up, create a fraction, and decide what the answers are. The Red Cross is not a particularly good example because a lot of information exists about it, and I think that determination would be pretty easy. But a private foundation in the United States that wants to support foreign charities, and many do, many more used to, but many do, can do that only 3 ways, and the third way is pretty new. I don't even know whether Ed ever was able to use it. I'll ask you in a minute. The first way is to say the foreign entity is the equivalent of a U.S. charity. It's called a foreign equivalency determination. In order to do that, you've got to get a lot of information about the foreign charity and find out everything about it. And is it the equivalent of a U.S. charity? Does it meet all of the 501c3 tests? And does it, in addition, qualify as a public charity, that is to say, not a private foundation? Many U.S. private foundations that give gifts to foreign charities make those determinations, the foreign equivalency tests, and their lawyers spend a lot of time on that with the help of local counsel. It's very time-consuming. That's one way. There's a second way to do it, and that is to exercise so-called expenditure responsibility. I'm going to come back to the first one in just a minute. In 1992, the service helped a little bit with the foreign equivalency determinations by issuing some guidelines that U.S. private foundations could follow if they wanted to make the determination, and it helped a lot because they were pretty simple and relatively formal, and they said exactly the questions you had to ask, and they even gave a form of an affidavit that you could get from the foreign charity if you wanted to use it. It's Revenue Procedure 92-94, it's still there, but it isn't perfect. And every time there's a change in the foreign entity, in theory, you have to go back and redo it. But that's one, foreign equivalency determination. The second is expenditure responsibility. The qualifying distribution rules allow a private foundation to make gifts even to things that aren't charities, as long as the money is going to be used for purposes described in 170C2, charitable purposes. If the donor or private foundation checks on it, you got to get, and there's a list of things you need to do. You got to ask them what they're going to do. You got to check on them. You got to get reports. You got to look and exercise some due diligence. It's called expenditure responsibility. That's burdensome too. Some U.S. private foundations do that. Others shun it like the plague. The third route, and I'm going to ask you in a minute which of those you used, which of these 3 you used primarily at CertFed. The third route is being explored now, and to the extent that it becomes workable, it could be very useful. I think of it as the qualified intermediary route, and I do that because it comes from another example in the code where the service was helpful. Because similar issues arise when U.S. people make payments to foreign people. Typically, there's a requirement that a U.S. person making payments of certain kinds of income has to withhold tax here, because we probably can't reach the foreign person and collect the tax later. So the tax is withheld at the source. But not all payments are subject to withholding, and part of the exception depends on the status of the foreign person. So you get in the same kind of question for this regular tax withholding. How do we determine what the foreign person is like? And some years ago, the service helpfully created a system in which a qualified intermediary, read the Good Housekeeping seal of approval provider, could look at foreign entities and put a seal of approval on the foreign entity and say, this one is not subject to withholding, and other people could rely on that. And that was useful. It's a qualified intermediary type thing. The service is now exploring the possibility of setting up such a system for this area, for private foundation giving, so that instead of each foundation having either to do the foreign equivalency test or the expenditure responsibility test, each private foundation could rely on someone else's determination of the status of the foreign entity, the so-called qualified intermediary rule. It's not fully effective. What did you do with service?
Well, we in a certain sense, in your definition, were lucky. You know, we chose, first of all, we made no international grants. So it took most of the pain out of the whole subject. But on your second point, expenditure responsibility, the trustees of the foundation I work for were very reluctant to do it on, I wouldn't call it philosophical, but almost a personal complexity basis. They simply couldn't get their minds around what it meant. And it also does take a lot of staff time in order to figure that one out. So for the most part, we avoided the issue of expenditure responsibility, and I think most American foundations do the same.
And in fact, what's happened, it's really important, is that these rules, you can understand the reason for the rules, but the rules have chilled international giving because the administrative burdens are severe.
Right.
And there's very substantial evidence that the existence of the need to do any one of the first two, we don't know much yet about the qualified intermediary test, but either the equivalency test or the expenditure responsibility test has substantially reduced the amount of private foundation giving to international organizations, which in my view is an unfortunate result.
Anthony, what did you do at Rockefeller?
We're switching the first two. For equivalency determination, often we had a number of regional offices. So like oftentimes in places like Thailand, for example, the regional office would be asked to actually help assist the regional organizations to see what they achieve for equivalency determination. But a lot of course, the grantees were relatively established, so this was something that was this is fairly routine. And then the expenditure responsibility was necessary, however, because we did give to NGOs in a number of countries where, in fact, they were too small, they couldn't achieve the type of standing. I don't know the rules well enough because this type of something we were sort of insulated from. The lawyers took over, and our law firms took over at this point for this sort of determination. So there are far more wiser minds on this, I'm sure. But when we gave to governments and education institutions abroad, it seemed like it was a lot easier ride on things. I guess there must be something that allows them to have much more.
There's a separate provision altogether in the code that deals with giving to governments and government entities, but there's a very complex determination about what's a government entity too. Part of the problem outside the United States is that in many countries where the needs are greatest, the legal regime governing NGOs is still weak and developing. And when that's true, there may not be in place the kind of law that we would expect here. For example, virtually every state in the United States now says that if you want to form a not-for-profit corporation, the law itself says that there will be no inurement and that on liquidation all of the assets must remain a charitable solution and go to another charity and so forth and so on. Outside the United States, there are many places where the need is vast and those laws aren't in place. If those laws aren't in place, it's very hard to do a foreign equivalency determination. The entities probably wouldn't qualify as charities here. Then you're stuck with expenditure responsibility. That too is very difficult. Imagine expenditure responsibility for a gift to an NGO that's trying to deal with the agonizing problems in Darfur. How are you going to find out how they allocated their funds? Which people received the money from them? Were those people really needy people as opposed to gingerweed or what have you? Incredibly complex stuff. And although the rules are rational in some sense, the burden of trying to comply with them has the net effect of chilling a whole lot of international philanthropy.
Two questions. Where there's a community foundation internationally, is it possible then for a private foundation to give its
If you know it's a community foundation, what you want to be be able to show when you call it a
And then
community
it could
foundation
get out to.
is that it's a charity, as we would define it, question one, and it's publicly supported, as we would define it, question two. The fact that it calls itself a community foundation won't work, because if it did, Osama bin Laden would set one up.
But it might be easier than trying to do.
It's not
it.
easier, you just have to make the same determination. The title won't take you anywhere. If it was enough, if it made it easy just to call yourself a community foundation, all the bad guys would form things called community foundations, right? It won't work.
The other
label
question-
won't work.
How does the service look at lobbying in the context of another country?
It's a little confusing. If you ask them for their general rule is that lobbying is lobbying, and they don't have any foot rule to get around the restrictions in 170C2, B, and 501C3. But in foreign equivalency determinations, the service in practice is willing to allow a certain amount of flexibility. I'll give you an example. In the United States, in the wake of the whole desegregation conflagration, some of the earliest cases involved private schools who were discriminatory. From then, from the 50s, right through to today, there are special rules that affect private schools. And in order for any private school in the United States to maintain charitable status, it must on an annual basis provide information that other charities don't have to provide. And that information includes efforts that they've made to recruit without regard to race and ethnic origin and so on, and has to give numbers. Fractions have to be created of admissions policies. In Canada, collecting those data is against the law. Can you give to can a private school in Canada be a charity? You can't get the information, literally against the law to get the information in Canada that is necessary to have in the United States. The service has repeatedly ruled that it is okay, and that it won't apply with rigid strictness all of the U.S. rules in making the determination outside the United States. How far that flexibility goes is uncertain, and for sure it's hard, still hard. But there's some flexibility, and in some countries, emerging countries, the state is everything. It's not a big private sector, and almost anything you do is, in some sense, could be in some sense thought of as lobbying. And there is some flexibility in the equivalency determinations, but the boundaries are unclear.
How does, suppose I'm Osama and I want to set up a charity, I'm Osama bin Laden, and I want to set up a charity for my religious schools. Why would that not count? Or maybe would. Could it pass the test?
Well, you got to tell me more.
Okay.
I mean, charity for a religious school may count unless, for example, it discriminates on the grounds of race. That's Bob Jones University.
Okay, it
That's a
doesn't.
religious school.
It doesn't.
So
Takes
if you
in
go for
all believers.
religious
take
school,
girls?
You don't need to set up a charity
All
for
believers.
your religious school, because if your religious school does everything, it meets all the tests, in itself is a charity.
Okay, so that could be all right.
All right for what? I mean, sure, it's all right.
But you can give, a private foundation could give money to that.
Oh, sure.
Okay.
That's U.S. If it's outside the U.S.
No, just outside the U.S.
Well, if it's outside the U.S., the question is the same. Is it a kind of organization which would be charitable in the United States? Can I find out by looking at it? I know it says, I'm a religious school, right? But I have to see, does it discriminate on the grounds of race or ethnic origin? I gotta do that test. Is it set up so that under the law, as it applies to it, there can be no private immunity, so that on liquidation, all of the assets have to go to a charity. I need to get a translation of its certificate of incorporation. I need to look at the local law. I need to make an equivalency determination, and the label won't do it for me.
Your rule number 3, who can be a qualified intermediary, because they're acceptable not just to the foundation, but also to the IRS.
Correct. So we don't know enough about this yet, and there are some institutions that are talking about being willing to be the Good Housekeeping Seal of Approval provider, but a lot of things have to be put in place. They have to be acceptable to the service, they have to be credible to the field, and you need to put in place some immunity rules, because no one's going to step into the middle and make those determinations and then be at risk for having made a mistake without knowing what the liabilities are. So a lot more process has to go forward, but in my view, there's serious energy behind it. There's willingness on the part of some institutions to step into that gap if the rules can be clarified. I don't know at what pace we'll see that, but it would be a helpful addition to international philanthropy if it could be done.
Presumably,
kinds
that
of-
would be something that the committee that you described, the ACT committee, would look at as one of the issues.
And did. There was a conference of some members of the committee and some members of the service in Washington on this issue last week, and we went through a whole list of things, and that was one. And if they can, and they understand the benefit of it, so it would be good if it happened.
Sorry, I'm sitting at the back here because I didn't expect to be engaging very much. I was very tired at the end of the class, but I'm not asking you too many questions. You mentioned certain kinds of institutions. Perhaps you don't want to name these institutions, but are they of a consulting company type? Are they of a supra NGO type? Are they of the World Bank type? What kinds of institutions
Well, it
are
would be the World Bank. The ones of which I'm aware are some accounting firms and some NGOs. But, you know, it's kind of early days, and which would be acceptable, because they have to be acceptable to the foundations as well as the service. And whether they would be willing to act depends on clarification of the duties, responsibilities, and liabilities. So I think this is still early days, but I would be optimistic that if the IRS moves forward with this, and I think the IRS would really like to do it, and within some reasonable period of time, there will be some structure in which this can happen.
I have an idea, this is a great idea. There's a great center on law and philanthropy at NYU. And this would be a great way to get a new revenue stream. You can create that.
And we're always looking for something to do.
I couldn't resist.
Yeah. Actually, it's a matter of public policy, Joe.
Yeah.
Yeah.
Well, you have to talk to Ed about it.
Yeah.
I don't know anything, I don't know. Not good.
Or Rich.
Well, Harvey, let me push you on an early remark that you made, and then a lot of the qualification, which is clearly historically, or certainly in the last decade, the growth in international philanthropy has been substantial, double digit. I think people in our game can name easily a dozen major philanthropies doing work overseas. And yet, what seems to be the case in parsing out the work being done internationally is that's enormously difficult to do, or to do legally. Now, does the community of donors feel comfortable enough to go ahead and do all this? Do they not pay much attention? Do they hire the lawyers to get in the loopholes?
There are teams of people working on this. It's really heavy lifting. Some of the major foundations that have substantial international operations, and you and I can name close to a dozen that have really substantial international operations, have teams of lawyers that work on this all the time, and have to in order to, and they use all of the relevant devices. They haven't used the qualified intermediary device yet, this isn't mature, but they use all of those devices. So they do a lot of expenditure responsibility. They do a lot of foreign equivalency determinations, and they bitch about it because it's not charitable. It's a frictional cost, and you bitch about that the same way as you bitch about commissions on trades on the market if they're too high. You don't want the frictional cost. It's more efficient if you can get it done with less frictional cost. But at the moment, it's a substantial problem, and I think even more than that, because it is a frictional cost, but a very small amount in terms of the budgets of the organizations that do it regularly. The big problem for me is that it's a tremendous chiller for the many organizations that won't venture into the field, even though they're reasonably substantial. And so what's being choked off isn't so much the Ford Foundation or the Gates Foundation or MacArthur. What's being choked off, or Mellon, what's being choked off is, we talk about what now, 73,000 private foundations or so in the United States. My guess is 72,000 of them never go near the edge of the water because it's too hard. Maybe they wouldn't anyway, but if they wanted to, it would be better if it was easy.
You know, the growth of community foundations in international giving is really quite striking. It's the largest annual year-to-year growth in anything that community foundations do on the international side. For the last 5 years.
For what it's worth, they have problems that are analogous but not identical, because they too have a worry. Their worry isn't the same. It isn't about qualifying distributions. But if they made a transfer, so let's move to, and this is another question about private foundations.
I don't know if this is private or not, but I'm thinking about all the diaspora giving that has been substantially growing in this country. So, for example, 50 million a year goes back to the Philippines or India.
It's
Or
not
that's just individual,
Transfer.
even if they create vehicles in this country?
Doesn't matter. I give, the old, people always say this, charity begins at home, remember? That actually comes from an ancient play, and I once knew this, but my synapses no longer remember. But it's a satire, and it's a satire, talking, I think, Greek, but maybe Roman, could be a little later. And it's a satire about somebody who goes to a wealthy person for a charitable gift and is promised a charitable gift, and sometime later goes back to the donor who made the promise and says, "You ready to give me the gift?" And he says, "No, charity begins at home," by which it means he reneges. He's Welsh. So the original meaning of charity begins at home is, I'm going to keep it. I'm not going to honor my gift. That's where it really, that's the original meaning of that phrase. If I decide that the family living next door is very poor and I want to help their son go to school and I pay his tuition, that's not charity. It's very nice, but it's not charity. I get no deduction for that, and it's subject to a gift tax. In order for a gift to be charity, it has to be to a class which is indefinite and open. Otherwise, the law won't step in to protect it. So no matter how nice it is that I take care of my children or my family or friends or what have you, that's not charity. And it will be governed by entirely separate rules.
I have a question. Have you noticed any particular trends for foundations with respect to their funding of international program priorities? And with all of the restrictions and sort of legal acrobatics that you've been describing, have you noticed that U.S. foundations have had to jettison certain program priorities for funding or streamline certain ones? Or
I can answer that
certain
two
areas?
ways. First is I'm a poor lawyer and know only a little bit about what goes on in the real world. And there's no way I would know trends of that kind anecdotally. The data to which I referred earlier are vastly inconsistent to me, but there are studies of international grant making, and the Council on Foundations every year or two puts out a study of international grant making by their members. And the Foundation Center, I think again, periodically, not every year, will do a survey of the private foundations which it tracks to see what their giving is, and one part of that deals with international giving. So some data are available, and I assume trend lines could be found, but that's, I don't know.
They published it this year in May.
Foundation Center?
The Foundation Center published it. I think it's now annual, their report on international giving by foundations.
And if they do it, it's up on their website, and you can download it as a PDF.
Correct.
So here's a much bigger question in the sense, I'm just taking time because I think it's of some value. We rarely get someone with your background in certainly the global world, but the question of globalization and the blurring of national boundaries would seem to make the matter of international grant making for a typically domestic American foundation or corporation much more difficult. Laws come into conflict with each other more regularly, et cetera, et cetera, et cetera. Is it possible to make some connection between increasing globalization and philanthropy in a positive or negative way?
I think the answer to that is that it's just complicated. In some places it gets easier, in some places it gets harder. I was in Moscow a year and a half ago, I think I'm right, a year and a half ago, shortly after Russia proposed changing its NGO laws. And the proposal was to improve regulation, improve transparency, improve accountability, and avoid funding terrorism, right? All good things, exactly what we said. And the upshot of that was the delicensing of 85 or 90% of foreign grant makers who previously had been licensed, because you need to be licensed to make grants into Russia, so that of the 190 or so that previously could do it, now down to 12 or 13. Anybody else from the original group cannot make the grant into Russia under these claims. Some of the people that have been disenfranchised are terrorists like MacArthur Foundation. The organizations have to be registered in the entirely new government ministry. It was created so that in accountability and transparency, organizations that have been working on the ground as presumably good NGOs, but I don't know on the merits, could no longer operate without So the problem is that under the rubrics, which we would treat as perfectly benign, an awful lot of people concur. And that's true around the world. Zimbabwe, just 4 months ago, Mugabe said that foreign aid into Zimbabwe would no longer be permitted except by people who can certify they're not part of the colonial powers trying to bring down his regime. Which meant that all of the human rights organizations had to stop activities. They literally stopped. So I think it is terribly complicated. On the other hand, there are many countries in the world that are getting better and more flexible about this. So, I mean, I can count Australia, South Africa, Canada, certainly, which have substantially improved their NGO regime and substantially improved the flexibility with which you can deal with them from outside. I think it goes country by country, and I don't detect any simple pattern except that you need to attend to an awful lot of details, and you always need to rely on counsel to do some checking. So it's not easy.
Is there much harmonization in Europe? It seems to me there are movements to harmonize their foundation center in Brussels, but I don't know what tangible is coming out of it.
The potential is there, but there's resistance too. We talked about this years ago when we were in Kurdistan.
Yes.
Because the EU could put out harmonizing rules for what is a charity and for what fiscal treatment would be permissible for gifts to other parts of the community. The latter I understand they have done, but I don't know enough about it. So as I understand it, it is now an EU rule that if Germany gives tax relief of some kind to a German donor who gives money to a German organization, they must also give that tax relief to a German who gives money to a Brussels charity. I think that is in place, although I haven't read the text. But the bigger effort, the bigger hoped effort would be for a single kind of entity that would work across the EU, and I don't think that has to happen.
Hasn't happened in the banking world either yet.
No. So I think that's hard.
One more question, anybody? It's been a great 101, 102, 103. Well, on behalf of the group, we'd like to thank Harvey for a fast tour through the very big complexities. So,
thank you all.
Thank you.
What's going to be after this?
Really makes me feel kind of cool.
I can't believe you hear you say that. I thought it was and you feel that way. Oh, yeah.
You know, I used to play chess. Well, I guess
Yeah.
But, you know, I knew how many steps I could do, and he just, you know, he just zooms through
Yeah,
this.
yeah, he saw I had several chess moves.